Good morning, everyone. On behalf of the Fort Worth Lawyers Chapter, I'd like to welcome you to the 4th Annual Texas Chapters Conference. For those of you who don't know, my name's Diane Kozub, and I'm the chapter's president. We are delighted to host the conference in Fort Worth this year. And if you're from out of town, we hope that you were able to come a little early or be able to stay a little bit later to take advantage of the cowboys and culture that Fort Worth residents are so proud of and very fond of. And as for the conference, I'd like to mention right here that the representatives from the Texas Review of Law and Politics are here. They published a symposium of last year's conference, and they're going to do the same thing for this year's. So pick up a copy out there at the registration desk of last year's conference. This year, to channel President Trump, this conference is going to be huge. The best that it's ever been. You haven't seen anything like it in your entire lives. From the luncheon featuring one very special Texas Supreme Court justice, to the 3 panels featuring 2 U.S. attorneys, 6 federal court justices, including 5 from the Fifth Circuit, and nearly a dozen or so nationally recognized experts from the government, state, and nonprofit sectors, including DOJ, HHS, the Texas Governor's Office, the Texas Attorney General's Office, Heritage Foundation, Texas Public Policy Foundation, Beckett, and First Liberty Institute. Only the Federalist Society could put together a lineup like this. And of course, it takes a team to assemble such an impressive lineup and put this all together. And at this point, I'd like to express my gratitude to those teammates who organized and orchestrated this event. First, I'm personally grateful for the tireless work of our Executive Vice President, Matthew Kaczmarek. Would you stand? Do the wave. From conception to completion, Matthew is responsible for the logistics of this event, selecting and recruiting speakers, finalizing and setting the itinerary, commissioning the artwork, coordinating with moderators, and making certain all deadlines and deliverables were satisfied. So if you think herding cats was hard, you should try herding the lions that are participating in this conference. Second, I want to thank the members of our steering committee, each one a Federalist Society officer or friend who worked to secure the venues and menus of this conference. Mark Pittman, a justice of the Second Court of Appeals, Darren Keyes from Kelly Hart Holman, Philip Vickers, Canny Hanger, Mac Ed Swindell from Whitaker Chalk, Dusty and Chad Fillmore from the Fillmore Law Firm, Jeremy Kernodle from Haynes and Boone, and Becky Ricketts from the Dallas Lawyers Chapter. Finally, and most importantly, all the Texas chapters are very grateful for the invaluable support of the Federalist Society's national office in Washington, D.C. Eugene Meyer, Leonard Leo, the faculty division staff, the student staff, and the Lawyers Chapter staff. We are particularly grateful for one member of the Lawyers Division staff who is absolutely indispensable and lies at the heart of every Texas Chapters conference. And for that recognition, I'm going to turn it over to Texas Supreme Court Justice Jeff Brown at this time, who has traveled from Austin and is going to present a very special award to a very special person.
Thank you, Diane. And first of all, I want to congratulate the Fort Worth chapter on a great conference. We've got some wonderful chapters here in Texas and have had some good conferences, and I know we have a lot more wonderful ones to come. And we, as Diane said, we owe a lot to the national folks, and in particular, the Vice President for Lawyer Chapters, Lisa Ezel. Lisa is a fantastic person, wonderful person, almost the perfect human being. She has one significant flaw. She is not a native Texan. She loves Texas. She married a Texan. She loves coming down here, but she's not a Texan herself. Well, we are going to do a little bit to try and resolve that this morning. I have a certificate to present to Lisa, and I'm going to, where is she? Is she in here somewhere? Oh, there she is right there. Come on up here. She's even wearing cowboy boots. Okay, in the name and by the authority of the state of Texas, to all to whom these presents shall come, greetings. Know ye that Lisa Ezell is hereby commissioned an honorary admiral in the Texas Navy. This is the good part. With all rights and privileges appertaining thereto, and with the duty of assisting in the preservation of the history, boundaries, water resources, and defense of the state. Signed, Greg Abbott, Governor.
I know I do. Thanks.
And there's the letter from the governor.
Oh, that's awesome. I'll just say thank you. I do not have a speech prepared because I am very surprised by this. A couple of people, Justice Brown, my husband, who I now outrank in the state of Texas. Thank you so much. It's been a pleasure. The one person, there's one more person I need to thank for this, and that's Diane Kozub, who, if it wasn't for her, we wouldn't have a chapter here in Fort Worth to begin with. So thank you, Diane and Matthew. This has been one of the highlights of my career is working with you guys on these events. So hope you have a wonderful day, and thank you so much for spending the weekend with us here in Fort Worth.
I have to add, it comes complete with a $6 frame from the Walmart in Kyle, Texas, which I bought at $4.45 this morning.
And now I'd like to call up Justice Elizabeth Kerr from the Second Court of Appeals to do the introduction of the man who will do the invocation.
Good morning. I'm honored and thrilled that my good friend Monsignor James Hart will be doing our invocation for us. My husband and I have known Monsignor for a quarter of a century now, which is hard to believe. He is a former Episcopal priest who became a Catholic priest in 1996, and he is currently Chancellor and Moderator of the Curia here in the Fort Worth Diocese. And please help me welcome Monsignor Hart.
Thank you, Your Honor, for that gracious introduction. And good morning. Let us pray. Almighty God, who has given us this good land for our heritage, we humbly beseech you that we may always prove ourselves a people mindful of your favor and glad to do your will. Bless our land with honorable industry, sound learning, and virtue. Save us from violence, discord, and confusion, from pride and arrogance, and from every evil way. Defend our liberties, and fashion into one united people the multitudes brought to this great land out of many kindreds and tongues. Endue with the spirit of wisdom those to whom in your name we entrust the authority of government, that there may be justice and peace at home, that through obedience to your law we may show forth your praise among the nations of the earth. In prosperity, fill our hearts with thankfulness, and in the day of adversity, suffer not our trust in you to fail. To these ends, confer upon this society here gathered that wisdom and prudence of which you alone are the font, that its members may advocate for and defend in word and deed through the rule of law the principles enshrined in the Declaration of Independence, the United States Constitution and the Bill of Rights, upon which this great nation was founded and has risen, and without which it cannot long endure. All which we ask through Jesus Christ our Lord. Amen.
It is an honor to be here today to introduce Judge Howe, the man who I've had the honor and pleasure of working for nearly 5 years now, first at Gibson Dunn and later as one of his inaugural law clerks. Taiwanese by birth and Texan by marriage, Judge Howe's story is quintessentially American. He immigrated to the United States with his parents when he was a toddler and learned English watching Sesame Street. Now he lives in Dallas with his wife, Allison, who is also a distinguished appellate litigator, and their twins, Georgia and Quentin, where he serves as a federal appellate court judge. Judge Howe's career is as diverse as it is impressive. He has served in all three branches of the federal government, built one of the top appellate practices in Texas, and argued 50 cases in state and federal court. Judge Howe earned his BA with honors from Stanford University and his JD with high honors from the University of Chicago Law School. After law school, Judge Howe clerked for Judge Jerry Smith on the Fifth Circuit and later for Justice Thomas on the US Supreme Court. He also served in President Bush's Justice Department, first in the Civil Rights Division and later in the Office of Legal Counsel. Rounding out the branches of the federal government, Judge Howe spent 2 years as chief counsel to Senator Cornyn. Judge Howe has also served the great state of Texas. He took over for Senator Cruz as the Solicitor General of Texas, where he earned the distinction of being the only state Solicitor General to receive a CVSG from the United States Supreme Court. Judge Howe then returned to Gibson Dunn in Dallas, where he built a top-flight appellate practice and served as co-chair of the firm's appellate and constitutional law group. It was there that I had the extraordinary opportunity to work for and be mentored by Judge Howe. Just under a year ago, the president nominated Judge Howe to the Fifth Circuit, and he was confirmed by the Senate a mere 77 days later. I, of course, jumped at the opportunity to follow Judge Howe back to the judiciary and serve as one of his inaugural law clerks. It was there that I was able, to paraphrase Senator Cruz from Judge Howe's Judiciary Committee hearing, to help him transition from the second best appellate lawyer in his household to the best judge. Please join me in welcoming Judge Howe.
Good morning, everyone. Brad, I don't know where Brad went, but thank you. That was absurdly generous. As you all can see, clearly I hire only the best advocates as my clerks. And in that spirit, that same spirit of the difficulties of arguing an impossible case, look, today's panel, we're talking about the Supreme Court, Justice Gorsuch, potentially future Justice Kavanaugh. The timing of this panel today really could not, it's just too delicious, too good to be true. So as I was thinking about this last night, how could I construct an argument that today's panel is actually poorly timed? There's unfortunately only one way I could come up with to make this point. This is the second week of the college football season. A lot of exciting games that we could all be watching today, including my 10th ranked Stanford playing the horrible people at USC. Can you hear it? And so here's the argument. So may it please the court, I submit that today's panel is poorly timed for every college football fan in the audience today. Speaking for myself, at a minimum, I really should be wearing my cardinal red Stanford t-shirt right now. Although come to think of it, I am now a newly life-tenured federal judge. Aren't I supposed to get to do whatever I want? But no, instead today I'm wearing a suit, and there really is only one organization anywhere in the country who could have gotten me to do that on a college football Saturday, and that's the Federalist Society. I first joined the society 22 years ago as a first-year law student at the University of Chicago, and it has been an honor and a joy ever since to be a member of the society, not just intellectually and professionally, but also personally. That's because I first met my wife, Allison, at a Federalist Society event 21 years ago this fall. As an official matter, I know, Lisa, don't worry, I'll take care of this. The Federalist Society is officially a debating society, not a dating society. But for Allison and me, I think it was a little bit of both. Moreover, there's an even bigger reason why I am profoundly delighted to be here today, and that's because today we will later honor one of the most important and distinguished legal minds in the history of our great state, and that's Greg Coleman. I'm not going to steal the thunder of Justice Thomas or Judge Jones, and even if I wanted to, I wouldn't begin to know how. But I'll just say that Greg was a treasured friend, a wonderful mentor and human being. I would not be sitting here today without Greg Coleman. And come to think of it, without him, there are a lot of places that I wouldn't have been sitting either. Today's panel is obviously extraordinarily well-timed. Over the past week, the entire nation's eyes have been glued onto the United States Supreme Court. There are a lot of opinions about the nature of the hearings this week. I will choose to be positive. Any Supreme Court confirmation hearing should be a celebration to anyone who believes in the greatness of our Constitution and the separation of powers. After all, every Supreme Court hearing sits at the intersection of all three of our rival and competing branches of our national government. The President of the United States has just chosen a jurist who he wishes to place on the highest court in our nation's judiciary. The Senate is now weighing in on whether it shall grant or withhold consent to that proposed executive action. And of course, every one of these hearings is essentially a debate over what the Supreme Court has done in the recent past and where it might be headed. And this is, of course, the second time that President Trump has had the opportunity to take such momentous action. To help us discuss where the court has been over this past year and where it may be headed, the Society has truly assembled an amazing all-star panel. To start us off, we have John Bash, United States Attorney for the Western District of Texas. He previously served as an Associate White House Counsel, and before that, as an Assistant to the United States Solicitor General, where he argued 9 times before the Supreme Court of the United States. He clerked for a guy named Judge Brett Kavanaugh on the DC Circuit, and also for Justice Scalia. He was also an associate in the DC office of Gibson, Dunn, and Crutcher. So John will open our panel today with a discussion of Justice Gorsuch and his first impressions of the 2017 term, and he'll also close out our panel today with a discussion of Judge Kavanaugh and his potential transition to becoming Justice Kavanaugh. David Taylor is a professor of law at the SMU Dedman School of Law, where he teaches contracts and patent law. Immediately before joining the academy, he worked for 7 years at the law firm of Baker Botts in Dallas, focusing on patent litigation in district court and federal circuit. And he previously clerked for the current Chief Judge of the Federal Circuit, Sharon Prost. He's a member of the Advisory Council for the Federal Circuit, and he also serves as an advisor to the SMU Law School chapter of the Federalist Society. Most importantly, David and I are fellow lower school dads at the Trinity Christian Academy here in North Texas, and I've enjoyed seeing him at school. Professor Taylor will provide some statistical analysis of the past term and also survey some of the term's biggest patent and business cases. James Sullivan serves as Deputy General Counsel to Governor Greg Abbott. He previously served with me, actually, as an Assistant Solicitor General, and has also worked in law firms in both Austin and Washington, D.C., King & Spalding and Covington & Burling. He clerked for Judge Tom Griffith on the D.C. Circuit and is now a member of the Advisory Committee on Procedures for the D.C. Circuit. He will focus, appropriately enough, on some of the biggest cases this term from the perspective of the state of Texas. Aaron Streett is a partner at the law firm of Baker Botts in Houston. So I think by my count, we've got on the panel a 2-2 tie. We've got Gibson Dunn with 2, me and John Bash, and Baker Botts with 2, Aaron and the professor. Aaron is the head of the firm's Supreme Court and constitutional law practice and has argued twice before the Supreme Court. He clerked for Judge David Santel of the DC Circuit. There's a DC Circuit pattern here. And then Chief Justice Rehnquist on the Supreme Court. He's a past president of the Houston chapter of the Federalist Society, and he will focus on some of the biggest headline grabbers of the past term. So as I said earlier, after Aaron speaks, we'll come back to John, who will talk to us about Kavanaugh and the week he just had, and hopefully we'll have some time for questions. So John, will you start us off?
Thank you, Judge. I think you forgot in my bio to mention that I'm the second best lawyer in my family, although the best U.S. attorney, so that's good. And I know I'm looking forward to college football today, too. When we moved earlier this year from the D.C., Maryland area to Texas, to Austin, Texas, I figured we were getting an upgrade on college football, but that turned out not to be the case last week. So
It's too soon.
we got Tulsa this week at home, so hopefully it'll be okay. I guess I'm just tasked with talking a little bit about the Supreme Court nomination and confirmation process, and in particular Justice Gorsuch and how he has impacted the court over the last term, or during last term. This was my first kind of experience with the confirmation process, and now I've seen a little bit of the Kavanaugh process, although I'm not actively involved in that, but my wife is. But I was in the White House counsel's office during the Gorsuch process, so I got to kind of see a little bit how it works. I think as many of you know, President, then candidate Trump put out lists during his campaign. I think Justice Gorsuch was not actually on the first list, if I'm remembering correctly, neither was Judge Kavanaugh, but I think he was on the second list. And so in January 2017, I think it was January 31st, 2017, the president announced Justice Gorsuch's nomination. I was there in the East Room when they announced it. I believe the president interviewed, according to news reports, although I wasn't involved, other candidates as well. There was reports that Judge Hardiman of the Third Circuit was a finalist. But in any event, he ended up picking Judge Gorsuch. And then kind of the craziness began, the same craziness we've seen over the last couple weeks, although it might not have been as crazy when it was replacing Justice Scalia, because I guess the view politically was that you were kind of just trading an apple for an apple. But it was kind of amazing to see the process. I guess that's a flood warning. It was kind of amazing to see the process with Justice Gorsuch. I was involved as a member of the White House counsel's office in preparing him for his hearings. And this is the same way I felt about Justice Scalia and Judge Kavanaugh as a clerk for them. With Justice Gorsuch, really what he was behind closed doors was exactly how he is in public when he's on the bench during his confirmation hearings. We would hit him with all the questions. His intellect was amazing. His preparation was amazing. It was never kind of like, here's what you should say. He always knew everything he wanted to say. He was someone who was unbelievably independent, really cared about the independence of the judiciary. I know there was a public dust-up when he was a little bit critical of some of the president's comments about the judiciary. But that's who he is. I mean, he's someone who, he would always say it, I think he probably said it publicly, but he definitely said it in the moots, I feel it in my bones, the independence of a judge. And he showed that in his first term, I think. But there's this moot process. There's a process I was not involved with where you go and meet with all the senators. I've heard a little bit about that from Judge Kavanaugh's public statements. According to Judge Kavanaugh, those meetings are actually unbelievably substantive. And as he said at his hearing testimony, he walked away very impressed with all the senators and their staffs, asking really substantive questions in those kind of behind closed doors meetings. That was an interesting thing to me. I mean, I think the senators are really well prepared, especially senators on the Judiciary Committee, because they're looking at those issues every day. And then the confirmation process starts, and it gets to be a mix of the kind of the legal process, but also some, politics comes into it a lot. So I know Justice Gorsuch has had some really interesting opinions on complex legal issues that everyone in this room would be interested to debate and discuss. But, he had a case about a trucker where I don't think the legal issue was kind of like an overwhelming legal issue, but he ruled against the trucker who had abandoned his truck in the cold. And it was an outcome that probably most of us looking at would say that's not a great outcome. And he even said in a response, if a judge likes every outcome that he or she reaches, he or she's probably not a very good judge, because you're trying to apply the law, and sometimes the law is not written well, sometimes the law is written well but didn't envision this situation, and the equities seem to go the other way. But that's just the nature of writing general laws and trying to apply them to specific situations. But anyway, his confirmation hearing, the thing I heard the most about was this trucker case. And he has really interesting views on the criminal law expressed in his circuit opinions on administrative law, immigration law. And that came out a little bit, but you know, it's those little opinions that you write that really are not major precedential opinions, but that the facts look kind of bad if you're just talking about them equitably, that really come out in a hearing like that. So he ended up getting hit with this trucker case. There was like one or two other cases that were really kind of the facts of the case, totally abstracted from whatever statute he was interpreting. But I thought he did exceptionally well in that nomination process, and then he ended up, it was a party line vote in Judiciary 11-9. There were 20 members at the time. Now there's, I believe, 21. I believe the split is 11-10 now because, not to get too technical, but Doug Jones's election in Alabama shifted things on the Judiciary Committee. But he got party line vote out of Judiciary Committee, but then he got confirmed 54-45. He got some of the Democratic senators, Senator Donnelly, Senator Heitkamp, and Senator Manchin at least. Maybe that was only those three. And got confirmed. And you know, my experience with him in the moots was just, I mean, this is kind of a guy that really was born to be a judge and born to be a justice. He is extraordinarily thoughtful, extraordinarily cognizant of what the role of a judge is. And it was kind of eye-opening to see that behind-the-scenes process for a Supreme Court justice. It's exactly how I felt about Justice Scalia. My wife clerked for Justice Alito, and so I've got to know him a little bit. It's how I feel about him. Also how I feel about Justice Kagan. Justice Kagan was my professor in Harvard Law School when she was the dean and wrote me the recommendation for Justice Scalia, and she's really the epitome of a judge as well, although disagreeing with those other justices on certain points of law. So that was the process. In terms of, I guess my next topic is sort of my first impressions of him on the bench. And I mean, this was really a blockbuster term, and I know my co-panelists are going to talk about those cases. But you had, of course, Carpenter, which to me, I don't think we're going to talk about that one. Maybe that's the next panel. But Carpenter, to me, is the biggest criminal Supreme Court case in 20 or 30 years. Leon is the one I might say is like sort of the last big one of that magnitude. I mean, for those civil lawyers in the room, what Carpenter said is that you, when the police or law enforcement get records from cell towers where your phone connects to when it's trying to pick up a signal to figure out where you were at a given time, that is a search of the person whose phone it is for Fourth Amendment purposes, and therefore requires a warrant or an exception to the warrant requirement. And that is just a completely different conception of the Fourth Amendment than what has ever been articulated before, because those are not records that the person creates or even probably really knows about, except in a very abstract sense. You probably don't know where which cell tower your phone's connecting to, or even where the cell towers are. And those records are created by the phone company. If you were just kind of woodenly applying Supreme Court precedent, it would have come out the other way. They would have said clearly not a search, and they had said something similar for landlines back in 1979 or 1980. But it reflects a trend in the Supreme Court going to cases from Kyllo in 1999 to Riley, a case I had the misfortune to represent the government on, which was the search incident to arrest exception, and whether you could search a cell phone without a warrant pursuant to that exception, where the court is saying we're not going to apply in a wooden way old Supreme Court precedents to new technology. And so from the Justice Gorsuch perspective, what was interesting about Carpenter was that he dissented from the majority's holding, as did Justice Kennedy and Justice Alito and Justice Thomas, but they dissented on more or less the traditional type of grounds I just said. This isn't a search under traditional doctrine. Justice Gorsuch did a kind of dissent that read more like I would go even further than the majority, but nobody argued what I'm saying, so I won't do it in this case. He suggested, in a way that's kind of reminiscent of how Justice Scalia often thought about the Fourth Amendment, that because federal statutory law creates what it calls a proprietary right of the customer in certain information that a cell tower compiles and records, that the customer may well in fact have a property right in that information. Now that's a property right that doesn't, in my view at least, look like traditional property rights. It's not land, it's not even kind of intellectual property. It's a kind of a privacy type property right, but he read federal statutory law, what he calls positive law, to create a new kind of property right, or at least suggested it might, and wanted to wait further argument on that. So that was really interesting. To me, that was the most interesting thing he probably did all term, both because Carpenter was, in my view, the biggest case of the term, and because he, without extensive briefing on that point, there was a little bit, really kind of developed his own theory that he viewed, I think, as consistent with the original meaning of the Fourth Amendment, but also applying that original meaning to new technology and new ideas and a new statute. So that to me makes it really interesting where he's going to go in criminal law going forward. Justice Scalia, I think, was thought of as, in some cases, a libertarian on criminal law. I don't think it was really a libertarian impulse so much as his reading of certain provisions of the Constitution, the jury trial right, the Fourth Amendment, the Confrontation Clause. So it'll be interesting to see where Justice Gorsuch goes from there after that kind of non-dissent dissent in Carpenter. The other big area where he kind of stood out from the other Republican-appointed judges on the court, and it's something that the next panel is going to talk about extensively, is the DiMaia case, which I also had the misfortune to brief for the federal government. I don't know if you all are familiar with Johnson and DiMaia, but I did both of those. It's about whether certain sentencing provisions and immigration provisions of the U.S. Criminal Code and the U.S. Immigration Code are unconstitutionally vague. And a Johnson case had already invalidated one of those with Justice Scalia writing. Justice Gorsuch joined the 4 Democratic-appointed members of the court to strike down another provision that's very important, the definition of crime of violence in the Federal Criminal Code, as also unconstitutionally vague. In this case, it had been incorporated by reference into the immigration provisions. And I'll leave to the next panel to talk about all the implications of DiMaia, but just one thing to note. At oral argument and in his opinion, it was pretty clear that Justice Gorsuch did not see much of a distinction for vagueness doctrine between criminal and civil laws, or at least not as much of a distinction as the government was attempting to draw. And it'll be interesting to see where that goes in terms of folks who come in, like a landowner that comes in and says this Bureau of Land Management regulation is unconstitutionally vague. It's not a criminal law, but it's affecting my land. Just like deporting someone is, in many cases, as bad or worse than a misdemeanor criminal offense, taking someone's land is that bad as well. I don't know if that's where he's going or if that's where the court's going to go or if that's the right way to go. But I think that DiMaia, I think he concurred and joined the majority in part. I think that's going to be very interesting to see where it goes. And then I'll just give a brief summary of some. I won't talk about the holdings, but just to emphasize how big last term was and what a kind of major thing, major intro to the court it was for Justice Gorsuch. I mean, there was, of course, Trump versus Hawaii. There was Janus, which finally overruled Abood on whether you can force public employees to give union dues. There were a number of big First Amendment cases, this Minnesota case about whether you could wear political T-shirts into the voting booth. There was Masterpiece Cake Shop, which I know another panelist is going to talk about, but kind of ended in a very narrow whimper, but it's going to be back. There was what would have been the biggest case of the term, Gill versus Whitford, about whether political gerrymandering is subject to constitutional limits that are justiciable. The court got rid of it on standing, so that ended up not as big as it could have been. There was the Microsoft case, which was going to be about whether under the Stored Communications Act, internet companies have to give over information in their control, but that's stored abroad, in this case in Ireland. Congress amended the act right after oral argument, and so the issue went away. There was the NCAA case about whether New Jersey could legalize sports betting, and the court held that Congress saying that New Jersey could not do that violated the anti-commandeering principle of the 10th Amendment. There was a big antitrust case. So it was just a huge case and a huge intro to the court for him. And generally, he stuck with the other Republican-appointed judges, but Carpenter and DiMaia, I think, show a certain streak in the criminal law arena and in the arena of affecting individual liberty where he might depart from some of the other Republican-appointed members in the future. So I'll leave it at that and return to the Judge Kavanaugh stuff at the end.
Thank you. Thank you, John. Professor?
All right, let's just say it up front. I'm going to talk about the statistics first, then I hope to talk about a few of the business cases. Let's just say it up front, the 2017 term was a great one for the court's conservatives. They stuck together, right? Justice Kennedy, in particular, in 5-4 decision after 5-4 decision, sided with the court's conservative justices. I think that's how most will probably remember this term. They won't remember it as Justice Gorsuch's first full term. They'll remember it as Justice Kennedy's last term where he stuck with the conservatives. That said, Justice Gorsuch also stuck with the conservative bloc in vote after vote, with a few exceptions, like the DiMaia case. But you've got to remember, this was his first full term, and the alternative might have been Merrick Garland voting in these cases, and we had several 5-4 decisions. How would those have gone? We can only wonder. So, but in terms of statistics, let me focus first on how busy the court was, and Justice Gorsuch in particular. How was it? Well, there were 72 controlling merits opinions, but even that number overstates things a bit. The number of signed controlling merits opinions after oral argument, just 59. And how did Justice Gorsuch rate in terms of the number of opinions, majority opinions he wrote 7 of the 59, which is the median number. So he was on average just on average busy. But if you count all of his opinions, he had a total of 17 opinions, and that was 4th most of the 9 justices. How busy was he at oral argument? How was he at oral argument? He averaged 15.4 questions, if you're wondering. That, anyways, turned out to be 4th most on the court. So again, right in the middle. So how did the court decide the cases, and how did Justice Gorsuch vote? Well, a full 26% of the court's cases were decided by a 5-4 vote, which far exceeded the previous 2 terms, statistics of 5% and 10%, but of course those are not normal because of Justice Scalia's death and Justice Gorsuch's the delay in his confirmation. So if you really look at the previous 4 terms with the full bench, the rate of 5-4 decisions for 2010 through 2014 fell between 14 and 29% of 5-4. So again, the 2017 term was 26%, so that really did fall very close to the high end. So a large number of 5-4 decisions as a percentage of the whole. So how did Justice Gorsuch vote in those 19 cases decided 5-4? He voted himself in the majority in all but 3 of those 19 cases, so 84% of the time. How did that rate to the others on the court? That tied him with Justice Kennedy, but Chief Justice Roberts actually led the court at 89% participation in the 5-4 splits in the majority. What about all of the cases on which he voted? Justice Gorsuch found him in the majority in 85% of all of the cases. That ranked him 3rd on the court. Again, Justice Roberts at the top at 93%, but also behind Justice Kennedy at 92%. So overall, in terms of how he voted, Justice Gorsuch most often agreed with Justice Kennedy in terms of the judgment, least often with Justice Sotomayor. All right, so then you're probably wondering, what opinions did Justice Gorsuch write? We could talk about them by name, but let's think about it in terms of statistics. Well, as I mentioned, he wrote 7 majority opinions. It turns out 5 of those 7 majority opinions were in those cases decided 5-4. Another way to understand his contribution to the court's work, of the 19 5-4 decisions, he authored 5 of those decisions. And if you think about it, Chief Justice Roberts was in the majority in all of those cases, so Chief Justice Roberts assigned Justice Gorsuch authorship of those 5 cases, which I think shows great confidence in Justice Gorsuch writing those opinions. The result actually, too, if you think about it in terms of statistics, when Justice Gorsuch wrote a majority opinion in the 2017 term, his opinion on average garnered the least support among the other justices. Or the other way you could think about it, he had the most opposition to address in his majority opinions. So in terms of the statistics, at least, Justice Gorsuch was, on average, shared his load at the court, but his participation was particularly significant in the number of 5-4 decisions and in terms of his authorship of those decisions. So in short, right, it will come as no surprise to anyone in this room that his nomination, confirmation, participation in these cases in the 2017 term was particularly important. So I was asked not just to cover statistics, but to think about what we'll call the business cases, which it was a blockbuster term, probably not because of the cases I'm going to cover. So as Judge Ho said in our conference call when we were preparing, this is the appetizer. The dessert is coming later. We'll get to those opinions in a bit. But I was going to cover 3 cases, if I have the time, all business cases in the sense that there were decisions really impacting business interests. Of course, could also impact individuals' interests as well, and they do. And a good example of that is actually the first case I want to talk about, Epic Systems versus Lewis. This is where Justice Gorsuch wrote one of those majority opinions in a 5-4 decision. This was a case about statutory interpretation. The question presented in this case was whether an agreement between an employer and employee, where they agreed to resolve employment-related disputes by individual arbitration, in other words, they waive class and collective proceedings, whether that's enforceable under the governing statutes, in particular, whether there was a conflict between the Federal Arbitration Act and in particular whether the National Labor Relations Act sort of overruled the Arbitration Act. So the holding here was that they were not in conflict and that employees and employers are able to agree to waive collective actions. And so from the perspective of Justice Gorsuch, what did we learn about Justice Gorsuch? We probably thought he was a textualist. Well, this opinion, I think, would say we confirm he is indeed a textualist. If you read his opinion, you see he's applying canons of statutory interpretation. In particular, one that was important in this case is the idea that the court strives to read different statutes together so that they do not conflict. And he repeated that refrain over and over. But I think I'm going to read a quote here, which I think is particularly important to understand why the reasoning behind this particular canon of interpretation. He said, "Respect for Congress as drafter counsels against too easily finding irreconcilable conflicts in its work. More than that, respect for the separation of powers counsels restraint. Allowing judges to pick and choose between statutes risks transforming them from expounders of what the law is into policymakers choosing what the law should be. Our rules aiming for harmony over conflict and statutory interpretation grow from an appreciation that it's the job of Congress by legislation, not this court by supposition, both to write the laws and to repeal them," right? So he very clearly made it apparent that he views separation of powers as important in terms of statutory interpretation. There were some other good quotes that you're probably going to see in future briefs, right? There's a quote, "Legislative history is not the law." But I want to highlight as well, this separation of powers is an underlying theme of the three cases that I'm going to present. In this case, I think we are wondering what's going to happen to the Chevron doctrine. And he, in particular, in this case, said, "No party in these cases has asked us to reconsider the Chevron doctrine." And so that's I think, going to come eventually. It wasn't addressed in this case. But there he cited the SAS Institute case. And it turns out that's the second case I want to talk about. So the SAS Institute case, it turns out it's a patent case. But I'm going to focus on other aspects of the case. It just arose in the context of a patent case. This is another 5-4 decision, authored by the majority opinion, authored by Justice Gorsuch, joined again by the conservative justices. Another case of statutory interpretation. In fact, these two cases kind of fit nicely together in the sense that they really show he's a committed textualist. And so the question it presented in this case, it's a rather arcane one related to patent law, but it's an important one. So the American Vince Act was a statute passed by Congress that put in place a new proceeding where someone could go to the patent office and ask for patents to be invalidated after they had already issued. So the patent office would be tasked with revisiting its prior decision to issue the patent. And the particular question was whether, when the petitioner brings one of those petitions, whether the patent office must grant the petition with respect to all of the patent claims, or they could just pick and choose which of the patent claims they wanted to address. Well, this turned on statutory interpretation. The holding was that the patent office must address all of the patent claims. They cannot pick and choose, and it turned on a particular statutory interpretation, 35 U.S.C. Section 318. But importantly, in terms of what we learned about Justice Gorsuch in this case, he cares about the text. He goes into detail about the word shall. What does that word mean? He goes into detail about the word any. What does that word mean? Well, it turns out any was in the particular statute, and he said, in this context, any means every. But he didn't just look at the particular words, he looked at the overall structure of the statute. So it wasn't just the particular words. He wanted to put those words into context in the structural choices that Congress made when they crafted this particular overall statute. But just like in the last case, he also provided some interesting discussion of why it was important to approach the case in this way, and in particular with this idea of separation of powers. So here's another quote. So he said, "Each side offers plausible reasons why its approach might make for the more efficient policy, but who should win that debate isn't our call to make. Policy arguments are properly addressed to Congress, not this court. It is Congress's job to enact policy, and it's this court's job to follow the policy Congress has prescribed. And whatever its virtues or vices, Congress prescribed policy here is clear." So I think that explains why, again, in this case, he didn't have to deal with the Chevron doctrine. He said, effectively, this statute is not ambiguous, so we're not going to defer to the agency. And that's actually very similar to the Epic case. So in both of these cases, very similar, both on statutory interpretation, both 5-4 decisions, Justice Gorsuch demonstrating that he's a committed textualist. Probably no surprise, very confirming though, if you were wondering. So the third case, another business case, it turns out it's another patent case. This is the oil states case. And so in this case, Justice Gorsuch did not write the majority opinion. He wrote a dissenting opinion. Justice Thomas wrote the majority opinion. It was a 7-2 split. Justice Gorsuch wrote a dissent, joined by Chief Justice Roberts. Preliminary point on this case is that I think Justice Gorsuch's fingerprints are on why the Supreme Court even took this case. Because if you go back, the question presented in the petition in this case had previously been presented to the Supreme Court twice. And in those two prior instances, the court denied the petitions. They granted it in this third case. If you look at the timeline, the prior denials of cert came, the last one was in December of 2016. Well, Justice Gorsuch was confirmed in April of 2017. The cert petition was considered by the court the next month, and it was granted the month after that. And with Justice Gorsuch dissenting, you think he may have had a particular role in having this court, having the Supreme Court grant this case. What I'll also say is our own Allison Howe played a significant role in this case. She argued the case of the Supreme Court. She wrote the petition, so maybe it's the case actually that she drafted a better petition, which caused the court to grant this case, and I think that is definitely part of it.
I agree with your
right.
second theory.
Always nice to be affirmed by the judge. All right. So the question presented in this case, another patent case, that same procedure that the Congress put in place where the Patent Office could review its prior decision to grant a patent, that was challenged in this case on the basis that it was unconstitutional. So not a statutory interpretation question, a constitutional question. The argument was that that was unconstitutional under Article 3 of the Constitution because it was not Article 3 judges that were deciding those disputes. As well, there was an argument that those have to be decided by a jury. Well, the holding in this case, again, Justice Gorsuch in dissent in this case, but Justice Thomas wrote the opinion holding that this new procedure did not violate Article 3 or the 7th Amendment. I want to focus, though, on Justice Gorsuch's dissent. I think that's the theme of our panel. And I wanted to think about what did we learn about Justice Gorsuch in terms of his dissent. Well, while the prior two cases were about statutory interpretation, we learned he indeed is a committed textualist. In this case, we learn actually that he's indeed a committed originalist with respect to constitutional questions. And what's nice and interesting about this case is we have Justice Thomas on the one hand, Justice Gorsuch on the other, and what we have is a dispute over the history of how patents were treated at the founding of our country at the time of the Constitution. So Justice Gorsuch comes out one way and Justice Thomas comes out the other on this question. But here's how Justice Gorsuch presented the issue that he thought needed to be resolved to decide this case. He said, how do we know which cases independent judges must hear? The Constitution's original public meaning supplies the key, for the Constitution cannot secure the people's liberty any less today than it did the day it was ratified. So based on that view of how to decide the case, he goes into a lot of detail about what happened at the founding, how patents were treated at the founding. There's a discussion in both the majority and the dissent about the King's Privy Council and how they treated patents. Were they able to revoke patents? The Crown's advisors in England, were they able to revoke patents at the time of our nation's founding? Well, Justice Gorsuch said effectively, no, although there were some exceptions, those were remarkable exceptions. They related to patents on munitions during wartime. Those don't reflect common practice. And in fact, in each of those instances, the resort to the Privy Council was a last resort. And so in Justice Gorsuch's view, no. Our history shows that patents on inventions ought to be, in disputes about the validity of patents over inventions, should not be resolved by an executive body like the Patent Office now. They should instead be resolved by Article 3 judges. And so in terms of the idea behind his reasoning in this case, again, I would focus on separation of powers, which is easy to say when the dispute is over Article 3. But he had some strong language in his opinion related to separation of powers. He said the law traditionally treated patents issued under the Patent Clause very differently than monopoly franchises, which are, according to the majority, as if the government grants the right to operate a toll road or a toll bridge. He said, no, utility patents and patents on inventions, those are very different. And patents alone Patents alone, is that working? Patents alone require Article 3 judges. So here's a good quote in terms of this idea of separation of powers being a predominant theme in these three opinions. He said, Hamilton warned the judiciary to take all possible care to defend itself against intrusions by the other branches. It's for that reason I respectfully dissent. So that's how he summed up his opinion. So there's a theme of these, they're business cases, both in the statutory interpretation context and in the constitutional context. Separation of powers is very important to Justice Gorsuch. He emphasized that in each of these three cases, there's a robust role for Congress as compared to the courts. That was the statutory interpretation cases. And there's a robust role for courts as compared to administrative bodies, and that was the oil states case.
See if this thing is working good. I have to join Judge Howe and John in confessing to being the second best lawyer in my family as well, although I don't have the good fortune that my wife is a member of this organization. I'm talking about cases from last term from the state of Texas perspective, and the first one involves, as one of the named parties, my boss, Governor Abbott, in Abbott versus Perez, a redistricting case that actually started before my son Conan was born, and he just started kindergarten. That's kind of the timeline of how these things work. After the 2010 census, the state of Texas picked up 4 seats in the House because of the explosive population growth that we've enjoyed. And so redistricting was necessary. So in 2011, the Texas legislature passed a new set of maps. But those maps were never used. The effort kind of went to nothing because they were, of course, immediately challenged in the U.S. District Court for the Western District of Texas. And at the same time, this was back in the pre-Shelby County days, and so the state of Texas also had to seek pre-clearance for the changes to its electoral maps and sought that pre-clearance in the U.S. District Court for the District of Columbia. So in 2012, the Western District of Texas decided to redraw all of Texas's maps because we had not yet secured pre-clearance from the DDC. That went up to the Supreme Court of the United States, and the Supreme Court sent it back and said you need to redraw the maps again, but this time actually look at what the legislature did in 2011 and respect the state legislative role in the redistricting process. And when the Supreme Court that first time remanded to redraw the maps, told the Western District of Texas, make sure when you're drawing your own maps for use in the 2012 election, make sure that you don't do anything that would be unconstitutional or that would violate the Voting Rights Act, and have maps that are lawful. And so the good judges on the 3-judge district court in the Western District of Texas drew those maps. They were used for the 2012 electoral cycle. And meanwhile, the DDC denied pre-clearance, I think the week before Conan was born, I want to say. But eventually Shelby County made that all moot. And another thing made it moot too. In 2013, then Attorney General Abbott advised the Speaker of the Texas House of Representatives that because we had these 2012 maps that the judges had worked so hard to draw and that they had drawn under the mandate from the Supreme Court without any kind of legal flaws in them, why don't we just repeal the 2011 maps and enact the court-drawn maps as the legislature's maps. And so in 2013, in a special session, that's exactly what happened. The Texas legislature took the 2012 maps that the court had drawn and made them the state's maps. And so you would think, okay, that makes sense. That seems like a good way to kind of streamline litigation and hopefully turn the temperature down on these challenges. But eventually in 2017, the Western District of Texas said, no, the maps that we drew that you enacted with minor modifications, those were also illegal. So thanks. I guess if you're going to copy off of somebody's homework, make sure that you copy off the right persons or something like that. So the Western District of Texas said that there were violations of the Equal Protection Clause and the Voting Rights Act in these maps. And specifically, they said this because the Texas legislature in 2013 hadn't purged the taint of discriminatory intent by showing that when they took the court-drawn maps and enacted them, that they were having enough of a change of heart from the 2011 maps that they had drawn And so, you know, as my recounting might suggest, that theory didn't really go very well in the Supreme Court of the United States. 5-4 with Justice Alito writing for the majority. The Supreme Court held that, no, this kind of got the burden wrong. It's not Texas's burden to show that it had a change of heart or that the taint was purged or whatever you might say. Instead, it was the burden that the plaintiffs proved that in 2013 that the Texas legislature had acted with discriminatory intent. And Justice Alito then explained why, you know, after taking that error of law out of the case, the evidence, you know, pretty clearly showed that there wasn't any discriminatory intent. The intent was that reflected in then Attorney General Abbott's letter to the House, and then the sponsor of the bill, along with support, I should add, from one of the plaintiffs' groups for the maps that they were then challenging. I believe MALDEF testified in favor of these maps when we enacted them in 2013. And said that, you know, that's not a discriminatory intent. That's a pretty sensible one that you would try to streamline litigation, which is expensive and causes uncertainty. So the Supreme Court reversed as to all of the Western District of Texas's you know, bad grade of its own maps that it had drawn, except with respect to House District 90, which was an interesting situation. Essentially, there was a neighborhood here in Tarrant County, the Como community. It's a predominantly African-American community. It had been moved out of HD 90, and then at its request was moved back into HD 90. But then when it got moved back into HD 90, I believe Malk complained that it dropped the Latino population below 50%, so then they wanted some changes. And those changes were made specifically for racial reasons that one of the groups had requested to try to satisfy Section 2 of the Voting Rights Act. And the Supreme Court held that with respect to HD 90, as drawn at the insistence of one of the plaintiffs' groups, that there was not enough inquiry into whether it was necessary to avoid a Section 2 violation, and therefore it was an unconstitutional racial gerrymander. So that has now been sent back to the Western District of Texas. Hopefully, we're not going to go back yet again to the Supreme Court, but we'll see what happens. The Western District has entered an order saying that if the Texas legislature doesn't introduce a bill to change HD 90 yet again within the first 45 days of the legislative session that'll start in January of 2019, then it'll draw yet another set of boundaries. So stay tuned. There's also going to be briefing that I think is going to wrap in 2019, or in January 2019, about whether there will be bail-in under Section 3C of the Voting Rights Act. And you might be wondering, well, why would there be bail-in? And I'm wondering that too, because the supposed violation that was found with respect to the 2011 maps, which, as I mentioned, were never used in any election and have already been vacated. And so as Judge Smith, in a dissent from the three-judge district court opinion, I think pretty persuasively explained, those claims are moot and were moot at the time they were decided. The next case that I'll talk about is South Dakota against Wayfair. This is a big deal in the tax world and a big deal from the state perspective. There is a kind of a dichotomy between sales taxes and use taxes. Basically, ordinarily when you pay sales tax for a purchase you make here in Texas, the seller is going to collect and remit the sales tax. But then the question is, what do you do if it's an out-of-state seller? And ordinarily, right now, we do a use tax where the person who makes the purchase, the buyer, is supposed to remit the sales tax to the comptroller. The yield on that is not great. And so, you know, if you can't make the seller collect and remit, which under some old Supreme Court precedent you couldn't, this was costing the states, it was estimated between $8 and $33 billion a year. So why couldn't the states collect and remit or require that out-of-state sellers collect and remit the sales tax? And the answer was from a case called National Bellis Haas from 1967, where the Supreme Court had held that both the Due Process Clause and the negative implications of the Commerce Clause prohibited the states from requiring an out-of-state seller who had no physical presence in a state from being obliged to collect and remit the sales tax. And to modern ears, that might sound incredibly stupid. In fact, just recently, 9 justices of the Supreme Court all said, yeah, that rule is wrong. In 1992, in a case called Quill, the court had been asked to overrule this Bellis-Haas physical presence rule, but had declined to do so. Although they did say that the due process holding was wrong and overruled that, they said, no, we're going to stare decisis. Because it's a dormant Commerce Clause issue, this is something that the Congress could fix, and so we'll just do the stare decisis thing and we'll let Congress fix it. So, and in that case, there was an interesting concurrence at the time by Justice Scalia and joined by Justices Kennedy and Thomas, saying we're just doing this for stare decisis reasons, but we understand that Bellis-Haas is wrong and stupid and creates a tax shelter that's judicially created. But it stuck with it on stare decisis grounds. So the interesting thing in Wayfair, in a bold move by the South Dakota legislature, they enacted a statute that said, look, we're losing too much money on this physical presence requirement. There are not a lot of out-of-state sellers that have these physical presences in states like South Dakota and North Dakota, which is why they always show up on one side of the V in these important cases, like in Quill. And so South Dakota passed a statute that said, we understand we need the Supreme Court to change its precedent to do what we want, but we're hoping that they will. And we are going to require out-of-state sellers like Wayfair and some of the other big internet retail giants to collect and remit the sales tax. And the Supreme Court, another 5-4 decision, held that indeed that Quill and National Bellis-Haas's Dormant Commerce Clause physical presence rule should indeed be overruled. They all agreed that it was wrong. That it was wrong on the day that it was decided, and the split came down to a really interesting fight about stare decisis. So Justice Kennedy, writing for the majority, comes off of the Quill concurrence where he had said, kind of, I think what Judge Kavanaugh recently described as, precedent on precedent, and went the other way and said, we're not going to stick with stare decisis. And I think that from the state perspective, that might be the most interesting thing about Wayfair, other than the, perhaps billions of dollars that we're going to get, is what was it that got Justice Thomas and Justice Kennedy to come off of the Quill concurrence on stare decisis grounds and to now vote to overrule National Bellis-Haas? Justice Thomas has a delightful short concurrence where he invokes the Lord Westbury line about Lord Westbury had said, "I'm amazed that a man of my intelligence should have been guilty of giving such an opinion." And Justice Jackson famously used that to complain about an OLC, or to walk back from an OLC opinion he had joined before he was Justice Jackson. Justice Thomas cites that. Justice Kennedy, I think that the biggest clue as to why his view changed, and you'll see why this is intriguing from the state perspective, came in a case from a couple of years earlier, the direct marketing case, where he had pointed to this physical presence rule that was costing the states a great deal of money on very shaky Dormant Commerce Clause grounds, and in that case had written separately just to describe this as, quote, a serious continuing injustice faced by the states. So that was pretty promising, and I'm sure it had gotten the legislative pens moving in South Dakota. And so in explaining why stare decisis didn't control here, and why the court was not going to wait for Congress to clean up its mess, the mess that the court had made, but that the court would clean up its own mess, was this quote from Justice Kennedy's majority opinion. If it becomes apparent that the court's Commerce Clause decisions prohibit the states from exercising their lawful sovereign powers in our federal system, the court should be vigilant in correcting the error. So again, the court is going to clean up its own mess because what they had done was hurting the sovereign state of Texas and lesser states. And so that's really promising. And so to me, the interesting thing about that is that, query whether this is a situation where, as Massachusetts versus EPA is to standing doctrine, Wayfair is to stare decisis, perhaps, where if you've got some kind of, state sovereignty interest on one side of it, will the court take a special look to try to clean up its own messes and overrule its own precedent? No way to know for sure, but that would be great if it happened. Chief Justice Roberts' dissent, joined by Breyer, Sotomayor, and Kagan, said, we agree that this decision is wrong, but we just think we should stick with stare decisis. In the last case, and John already talked about it, and so I'll just touch on it really quickly here, is the Murphy versus NCAA case. In the PASPA, the Professional and Amateur Sports Protection Act, the Congress had taken the unusual step of issuing an order directly to the states and telling them something that they shall or shall not do. Specifically, it said that they shall not authorize sports gambling. And for those of us who have been state lawyers, your antenna immediately go up when you've got the Congress saying that state legislators or state agencies or state officials shall do anything, because you kind of go to the sullen teenager mode and you say, like it says who? You can't make me. And indeed, we have a whole constitution, and it's great, and it stands up for this principle in the anti-commandeering doctrine. And I think that the key quote from Justice Alito's opinion striking down the PASPA was this: "It is as if federal officers were installed in state legislative chambers and were armed with the authority to stop legislators from voting on any offending proposals. A more direct affront to state sovereignty is not easy to imagine." Basically, if the states can't get rid of their own prohibitions on sports gambling, that is not an enumerated power of the Congresses, and so the 10th Amendment reserves that power to the states, and that can't be done. I see that my red light is on, Your Honor.
Thanks to the Fort Worth Federalist Society and to Judge Howe for inviting me to be on this panel. I'll touch briefly, I know we're running out of time and we all want to hear John's comments on Judge Kavanaugh, but I'll touch briefly on two of the high-profile cases from this past term, Masterpiece and Janus. In Masterpiece, the Supreme Court held by a 7-2 vote that the state of Colorado acted unlawfully when it penalized Jack Phillips for declining to create a custom wedding cake for a same-sex wedding. Phillips brought free speech and free exercise challenges to that ruling. Conventional wisdom teaches that the court reached a narrow decision by ruling on free exercise grounds without reaching Mr. Phillips' claim that the state was compelling him to speak, that is, to create art in violation of the free speech clause. I want to challenge that conventional wisdom. But first, two other notes of interest. Justice Kennedy wrote the opinion. He was joined by the 4 conservative justices, as well as Breyer and Kagan. As I reread the opinion, I was struck by its parallels to Justice Kennedy's opinion in Planned Parenthood versus Casey in light of its rhetoric. In that case, Justice Kennedy sought to, quote, call the contending sides of a national controversy to end their national division by accepting a common mandate rooted in the Constitution, end quote. In Masterpiece, Justice Kennedy similarly sought to forge a national compromise in which the dignity of gay and lesbian persons is respected while sincere religious beliefs are protected and not equated by the government to bigotry. The lessons of history suggest that the court is more effective at deciding cases and controversies than mediating controversial social issues. Nonetheless, one critical aspect of Masterpiece is that 7 justices soundly rejected the proposition that traditional religious beliefs about sexuality are a mere cover for hatred of gay and lesbian persons. Justice Gorsuch's role was also noteworthy. Justice Gorsuch was the only justice who joined both Justice Kennedy's majority opinion for the court, which refused to reach the speech issue, and Justice Thomas's opinion, which reached the speech issue and would have held that the state had unlawfully coerced Phillips' speech in violation of the Constitution. Justice Gorsuch also added his own lengthy concurring opinion joined by Justice Alito, which dueled with Justice Kagan over the scope of the majority's free exercise holding. As in many other cases this first full term, Justice Gorsuch was a force to be reckoned with. While the court declined to reach Jack Phillips' speech defense, it meaningfully strengthened and clarified the law on free exercise. The court reaffirmed its decision in Employment Division versus Smith, which held that generally applicable laws may burden religious exercise so long as they treat religion neutrally and they are not rooted or demonstrate hostility to religion. While Colorado's actions against Jack Phillips were based on a facially generally applicable law, the court concluded that the state acted with hostility to Mr. Phillips' religious beliefs. The court found 2 signs of hostility. First, the Colorado Civil Rights Commissioners that meted out Mr. Phillips' penalty made statements indicating their hostility toward religion, the most egregious of which asserted that freedom of religion had been used to justify, among other things, the Holocaust. Most of the legal commentary on the court's decision has focused on these uniquely offensive remarks, suggesting that the court's decision must be narrow because it turned on these presumably rare sentiments. But the court went on and noted a second definition of hostility, a second indication of hostility that some have overlooked. Namely, the commission had disparately treated others who refused to serve customers that were protected by the state's anti-discrimination laws. The court recounted 3 instances in which bakers refused to create cakes containing religious text disapproving of homosexuality. Yet the commission did not pursue these bakers for discriminating on the basis of religion, nor did they make any persuasive attempt to reconcile their treatment of Jack Phillips with their leniency toward these other bakers. This disparate treatment raised the inference of religious hostility toward Mr. Phillips. The concurrence by Justice Kagan argues that even this holding is extremely narrow because the commission simply needed to do a better job of explaining why the bakers who refused religious messages acted lawfully while Mr. Phillips acted unlawfully. But Justice Kagan is unlikely to control a majority of votes in future religious liberty cases. That is why I believe that this holding lays the groundwork for the court in future cases to rigorously police whether laws that are generally applicable on their face are in fact being applied with hostility toward religion. That is the approach suggested by Justice Gorsuch's concurrence, joined by Justice Alito. And that would be a significant holding. Indeed, commentators such as Doug Laycock and Michael McConnell have suggested that many states routinely apply their facially neutral laws against religious traditionalist objectors while allowing many exemptions for other reasons. Quoting his own opinion for the court in the Church of the Lukumi Babalu Eye versus the City of Hialeah, Florida, Justice Kennedy emphasized that, quote, even subtle departures from neutrality and, quote, even slight suspicion that state action stems from hostility to religion are unlawful. My sense is that lower courts had largely forgotten those words from Lukumi and had emphasized Smith's general rule while treating Lukumi as limited to its relatively unusual facts. This case isn't about animal sacrifice. It's a generally applicable law, therefore we apply it. But if Justice Kennedy's emphasis on the limiting principles of Lukumi is really the standard that will be applied to religious objections in the context of anti-discrimination statutes and other facially neutral statutes that may burden religious exercise, then the court's holding in Masterpiece is perhaps broader and more important than if it had decided the free speech issue. After all, many religious objectors will not have a colorable free speech claim, as Jack Phillips did. Consider, for example, the pharmacist in the Stormans case out of the Ninth Circuit who declined to stock emergency contraception in violation of a Washington state statute. The Ninth Circuit upheld the law as generally applicable under Smith, and the Supreme Court denied cert over the dissent of 3 justices who pointed out that the statute was riddled with non-religious exemptions. Under Masterpiece, it seems likely that the court would sustain the pharmacist's free exercise claim in light of the statute's unequal treatment of religious objections. Of course, it's too early to say how the lower courts will apply Masterpiece, but it can be safely observed that Masterpiece calls into question the last couple decades of lower court decisions that treated Lukumi as a sui generis case and almost reflexively upheld statutes that were generally applicable on their face against free exercise challenges. Masterpiece, in my view, far from being a meaninglessly narrow decision, is a timely reaffirmation that at a minimum, the government owes neutral, even-handed treatment to religious objectors before it seeks to coerce actions that violate sincerely held religious beliefs. Let me briefly touch on Janus, which raises a lot of interesting questions of stare decisis when it's juxtaposed with Wayfair, and of course the extensive discussion of stare decisis at the Kavanaugh hearings. So as John mentioned, this is the case in which the question is whether public employee unions can compel non-members of the union to support collective bargaining efforts through agency fees. And the plaintiff in the case was an Illinois public employee who did not support the collective bargaining efforts of his union because it was bankrupting the state. As we know, Illinois has well-known financial problems, and Mr. Janus did not believe it was responsible for public employees to be agitating for more pay and benefits in that context. This issue had been before the court once before in the Friedrichs case, which was argued before Justice Scalia passed away. The decision was issued as a 4-4 tie, and so the case came back to the court this term. So 2 quick points on Janus. There was a lesser-known part of Janus that I think is very interesting. The defendants, the Illinois Public Employee Union in the case, made an originalist argument that it pitched to first Justice Scalia and then Justice Gorsuch. The argument was that public employees had no First Amendment rights under the original understanding of the Constitution. Before rejecting that argument on the merits, Justice Alito's majority opinion had a little bit of fun with it. He said, surely public employees don't really want us to hold that they have no First Amendment rights whatsoever. That would require us to overrule 50 years of decision. We will not accept this halfway originalism. Then he went on to argue that, in fact, the original understanding of the Constitution and founding era history suggested that the founders would have blanched at the compelled speech that was being required in Janus. So the second point has to do with stare decisis. I think when you read Janus in a vacuum, it suggests a substantial weakening of stare decisis. Whether that means much going forward, we'll see. Certainly Wayfair has a very robust stare decisis discussion, even though it ultimately overruled the previous holding in Quill. Two important points on stare decisis. First of all, the court relied heavily on the fact that the previous decision in Abbott 41 years before was poorly reasoned. Typically, that does not carry very much weight in stare decisis analysis because you don't get to stare decisis analysis unless the previous decision was wrong. I guess there could be well-reasoned wrong decisions, but it seems like a small category. Justice Kagan called the majority on that point for emphasizing the poorly reasoned nature so much. Second of all, the court emphasized that the reliance interests here were not as strong as they initially appeared. You might think unions have come to rely on these fees. Many contracts were negotiated on the basis of these fees, and the court had in past cases said that where contract and property rights are at interest, the reliance factor is at its highest. But the court did a very interesting thing to reject that argument. It said unions should have been on notice from our decisions calling into question Abbott in the last 6 years, and it cited 2 decisions by the court that had criticized Abbott but had not overruled it. This is a very interesting concept. I wonder if we won't see it in the future. Certainly the idea that parties should be on notice that a decision is under threat should sound familiar to students of the Roberts Court. Our friend Greg Coleman argued the Nambudno case that called into question Section 4 of the Voting Rights Act. In Chief Justice Roberts' opinion in that case criticized it heavily, but did not overrule it. And then in Shelby County, he later said Congress was on notice of the questions about Section 5. Similarly, before Citizens United, the chief brokered a narrow decision in Wisconsin Right to Life versus FEC. He then said, a few years later in Citizens United, the line we tried to draw in Wisconsin Right to Life didn't work out. Congress was on notice. Therefore, we overrule our precedent in McConnell versus FEC. Very interesting to see how this all plays out with future cases where precedents will be challenged and the court will perhaps begin to build a record of calling into question the rationale of decisions without overruling them. I'll close with Justice Kagan's criticism, which I think John mentioned. Justice Kagan is the epitome of a judge, even if we disagree with her sometimes. But she said that eroding stare decisis was dangerous, and she said, relying on those past decisions of the court that were 5-4 decisions criticizing Abbott, she says, relying on them is bootstrapping and mocking stare decisis. Don't like a decision? Just throw some gratuitous criticisms into a decision, and a few years later point to them as special justifications for overruling the precedent. I think the reality is that stare decisis is a case-by-case analysis, and it will depend on a lot of different factors in future cases, but I did think that was worth mentioning today.
I guess that leaves me to talk about Kavanaugh. One thing I'll say the most interesting stare decisis to me thing of the term, one we haven't touched on yet, was in Trump versus Hawaii. The Chief Justice said something that a lot of nominees have said, but the court had never said, which is that Korematsu had been overruled in the court of history. So it kind of makes you wonder how many other things have been overruled in the court of history, because there are a lot of kind of early 20th century, late 19th century pretty odious precedents of the sort of Korematsu, like Buck versus Bell, or the Chinese Exclusion Act case that came up at the Senate confirmation, that I think probably you poll most lawyers or most law professors, they would say those have also been overruled in the court of history, but it's kind of, you wonder if the court's going to start saying that about other cases as well. And I do think, for people involved in the Federalist Society, or for people who found a lot to like in Justice Scalia's originalist approach in terms of trying to get judges to decide things objectively and not based on subjective policy views, it's pretty important to have an objective theory of stare decisis, because you can re-import all those same policy preferences into deciding which cases you're willing to overrule and not. And so if you have some case that matches your policy preferences, say you really hate out-of-state taxes, but you think was wrong, you could just say, well, I'm doing stare decisis, and if you don't have a really rigorous objective theory of stare decisis, you can use which cases you're going to revisit and not to re-implement your policy views. So that's something that's actually concerned me a lot, because there's factors for stare decisis, but a lot of them are factors that you wonder about the judicial competence to assess. I mean, reliance interests, are we taking sort of an economic poll of the country on reliance interests? How are we really deciding that? Is it just a couple of amicus briefs? That's not very law-like compared to what the words of the statute mean. So I think stare decisis and making sure there's an objective basis for stare decisis is a really important issue going forward, especially for people that think judging should be objective and not subjective. In terms of Judge Kavanaugh, hopefully Justice Kavanaugh, I thought he did exceptionally well at those confirmation hearings. That was brutal. I mean, to have to sit there for 30 hours or whatever it is, or maybe he was there for 18 hours, and answer substantive questions with very few breaks. I mean, it was unbelievable. His stamina was unbelievable. I thought the country saw that he's a judge's judge, that he tries to decide things objectively, that he's also aware of the real-world consequences. I think he spoke very movingly about racial disparities in the criminal justice system and in society in general, in some of his colloquies with Senator Booker. And that really epitomizes him. He's somebody that is a textualist. He's a constitutional textualist, as he said, on constitutional issues. But he's also cognizant that sometimes it really matters how the law applies in the real world. I mean, we're struggling nowadays with issues of how the original understanding applies to new technologies in cases like Carpenter, and that really requires an understanding of the real world. So does some of the cases touching on race, where you have to understand how race plays out in the real world. He had an opinion he talked about a lot, where he said that under Title VII, one instance of an African-American employee being called the N-word is enough for racial harassment. This might have gone away again, but one instance of being called the N-word at work, if you're an African-American, is enough to establish a racial harassment claim, and that the text says no racial harassment, but you have to have sort of an understanding of the real world, of what meaning that word carries to resolve a case like that, and I think that shows how his textualism interacts with the real world. I'll just make 3 points about the post-Kennedy court, assuming Judge Kavanaugh is confirmed, which we're all hoping. Well, I'm hoping. I don't know if everybody here is, but I'm hoping. First, I thank you. I think any justice replacing Justice Kennedy, there'd be all sorts of questions about the cases where Justice Kennedy joined the liberals and what's going to happen with those precedents. Those are a lot of social issue type cases, reproductive rights type cases, same-sex marriage, of course. I guess I'll just say 2 things about Judge Kavanaugh. One, he really hasn't expressed his view even as a lower court judge on most of those issues. He sits on the DC Circuit, so he's had a lot of very important separation of powers cases, administrative law cases, but I don't think he's ever had an affirmative action case, for example. So I know him very well. I was his first year clerk his first year, but I have no idea what he thinks on those issues. I have no idea what he thinks about Roe and Casey and whether those cases should be reconsidered. He had one abortion case ever. It was just last year. But what he did on his panel of 3 was the narrow middle ground approach, trying as best he could to apply Supreme Court standards. This was the case where an unlawful immigrant minor was in custody of DHS and wanted to obtain an abortion. And DHS said, we'd like to put her with a sponsor in the United States, which is what often happens with unaccompanied minors, and then that person, she can consult with that person before deciding to get the abortion. One judge on the panel said, no, she's entitled to the abortion right now. Another judge said there's no right, I think, if I'm remembering correctly, there's no right to abortion at all if you're an unlawful immigrant in the United States. And Judge Kavanaugh said, hey, look, the government has told us they can place her with a sponsor in plenty of time to get the abortion in a lawful way under state law. If that's all they're asking for, I'm going to look at the Supreme Court precedents on minor parental notification, parental consent. I'm going to apply the undue burden standard as the court has articulated, and this is my best reading of the precedent. I don't think you can tell anything from that opinion about what he's going to do if he's a Supreme Court justice in issues of Roe versus Wade and Casey come. It seemed like a narrow judge trying to apply the precedent as given to him by the Supreme Court with no view one way or the other on the merits of that precedent. So that's one. I just don't think he's expressed views on a lot of those issues where Justice Kennedy went with the liberals, so it's hard to know what he's going to do if he's confirmed. The other thing is, one thing he said a lot, and this touches on what we were just talking about, is that in his view, and I think this is right, stare decisis is constitutionally grounded, meaning that when Article 3 sets up courts and what the word court meant to the founding generation, it brought with it stare decisis because that's how courts in the Anglo-American tradition resolved cases. So when people say, well, 5 justices can overrule anything, I mean, that's like saying, well, 5 justices could say any taxes over 20% are unconstitutional, or 5 justices could implement any, Trump policy view. It's true if you had 5 justices not willing to do their job as judges, they could just start decreeing all sorts of unjustifiable things. But if you have 5 justices doing their job, they're actually trying to apply the law, and I think all current 8 justices on the court are like this. They're trying to apply the law as best they know how. And when it comes to stare decisis, if they agree, like Judge Kavanaugh does, that there's a constitutional grounding in stare decisis, then they're going to be conscientiously applying the principles of stare decisis to decide whether to overrule cases. They're not just going to get there and say, well, I'm overruling ones I don't like, period, because that's not what stare decisis is about. You look to, even given my qualms on how courts have competence to apply these factors, the traditional factors of whether the decision's unworkable, whether there's reliance interest built up on it, whether Congress can fix it, and so forth. Courts are applying those sorts of factors, and I think Judge Kavanaugh has made very clear he doesn't think overruling cases is just something you do when you think they're wrong. He's going to try to apply what he views as constitutionally grounded stare decisis factors. So I have no idea what he's going to do on those cases where Justice Kennedy would join with the liberals and those issues, and I don't think anyone else does either, and that's how it should be to have an independent judiciary. Second point, two ways that I can imagine he might shift court doctrine or help move the court along in ways that are not kind of 5-4 ways. One, separation of powers. I think he's known more than anything as a scholar and a judge who has resolved novel separation of powers issues correctly. The Peekaboo decision comes to mind. That's the PCAOB decision, I should say, comes to mind, which is the Public Company Accounting Oversight Board and the problems with removal and appointment in that context, or the alleged problems. And I think especially with newfound attention over the last couple years on the power of the president and the relationship between president and Congress and the courts, I think there will be a renewed focus on separation of powers at the Supreme Court, and I don't think that's going to be a 5-4 kind of thing. I think I could see a lot of 9-0 decisions on reinforcing the separation of powers as a guarantor of liberty. Just last term, you saw the Lucia case, which said that SEC administrative law judges are officers, and therefore they have been improperly appointed. And Justice Kagan wrote the case, and she was joined by a number of other justices. It wasn't 5-4. And I think what you see there is that those separation of powers issues don't cut along normal, quote-unquote, partisan lines at the court, and justices of all who have been appointed by both Democrats and Republicans think those separation of powers principles are key to preserving liberty and accountability in the government. So and that's a pet project of Judge Kavanaugh, and I think you're going to see him join with others on the court to reinforce those principles in a way that's not one of these kind of 5-4 things. The second area that'll be really interesting to look at is substantive criminal law. He had some really interesting colloquies with Senator Whitehouse on this at the confirmation hearing. He has an opinion emphasizing the importance and the due process origins of mens rea. That was in the context of a violent criminal that I can't remember exactly what the law was, but for some fact he didn't know about, it might have been the type of gun, he got like 20 extra years or 30 extra years. And I think I can't remember if he dissented or wrote the majority, but he objected to that strongly. He's also written a lot about acquitted conduct and whether, when someone's convicted of 1 of 10 counts, it's okay for the judge at sentencing to rely on the judge's belief that the defendant committed the other counts as well in deciding a sentence for the 1 count of conviction. He's written about the unfairness of that, although he's been bound by Supreme Court precedent to follow that principle, that the judge can rely on that sort of conduct. So Criminal law and especially substantive criminal law and separation of powers, I think, are two areas where you potentially see have a lot of influence and in ways that are consensus building on the court and that reinforce individual liberty. Last point I'll make about what I think he might be like on the court is, what he's really known for on the bench is writing. He always told me, and we're doing a lot of these kind of FERC cases that are very dense, even for an appellate lawyer. He really wanted to write things so that the average lawyer could pick it up and understand what it's about, even if it's on an extraordinarily technical subject matter that the lawyer has no familiarity with. I think I imagine he'll take that to the next level at the Supreme Court and especially on these big issues that get a lot of news coverage, try to write opinions that the average informed citizen can read, and even if they disagree with the bottom line or they don't like the outcome or they at the end of the day disagree with the legal reasoning, they will understand where he's coming from in a way that hopefully improves the image of the court as not just a partisan institution, but 9 people trying very hard to apply neutral legal principles to difficult issues. I think he's going to write in a way that's readable and that you'll read it and you'll understand. And I think some of the other justices do that very well too, and the Chief Justice is excellent at that. Justice Kagan is excellent at that. I think he's going to be someone else like that who when you read the quote in the New York Times or hear it on Fox News the next day, you'll say, I understand where the court was coming from. Maybe I disagree with it, but I understand where they're coming from. I think that's going to be very helpful for the perceived legitimacy and nonpartisan nature of the court among the American people. So with that, I don't know if you wanted to do questions, Judge, or...
Well, it appears that we are out of time, but I think it would be a shame to at least not allow 1 or 2 questions. Can we exercise a little bit of mercy? Okay. Are there any questions? Don't be shy.
Well, that makes it easy.
I guess we'll, oh, there we go.
Well, I'm sorry, I'm not familiar with that one.
Never
I think that question is best answered by Judge Howe.
Well, I'll be happy to follow in Judge Kavanaugh's footsteps at the hearing when he confirmed that he had in fact heard of the case.
Because of the late start, we can't have any more questions and answers. We're going to take a 5-minute break, but first let's have a round of applause for this panel.